Cheers. All right, let's get started. I guess I just clapped again. Again, just telling me not to clap. All right. Hi, everyone. My name is Joseph. I'm the managing partner here at Tsang and Associates. And today's show, we're going to be bisecting it into two sections. The first part, we're going to talk about news, what's going on right here, right now, that you don't see on the major media. We'll be taking immigration questions. So if you have any questions, feel free to ask. We're going to answer as many as we can. Usually we save about 10, 15 minutes after the news segment, answer all those questions. And then I'm going to film a live success story regarding an executive transferee, an L1 manager coming over to make, clothing in the United States and how we were able to get them over. That's a really fun success story. We're going to do that one, and then we'll answer some more additional questions. We are a firm that specializes in immigration, so feel free to ask us anything immigration related. We don't do all immigration type cases, so if we can't do it, we'll let you know. If you have any other questions you want to ask about the firm, about politics, about life, also happy to answer as well, okay? But we want to do this sort of as a public service for everyone. We're going to be recording these videos and we'll be releasing it on the YouTube channel. I know a lot of people here are watching on TikTok, on Instagram, on Red, but we're here trying to share as much information as we can. So today's news is regarding the question, should I still apply? Because with denaturalization going on, with the new giant billion-dollar detention center that is being built, with special immigrant juveniles potentially being canceled, being attacked, OPT students potentially not being able to use OPT, CPT students potentially not being able to use CPT, international students potentially not being able to work after they graduate. Should people still immigrate? Should people still apply? That's the question we're getting day in and day out. I was so surprised when I'm asking a lot of these clients, why are you here? Why are you asking us these questions? What caused this desire to inquire, right? And they said it's because of the denaturalization memos that they've been seeing. They're green card holders, not even yet citizens, and they are concerned about applying for citizenship because of the denaturalization news. And their concern is because they had a traffic ticket. Their concern is because they had, this marriage issue years and years ago, completely domestic, not a domestic abuse case. It's just because their date of marriage was off. Is that going to be a concern for their citizenship application? A lot of these concerns are completely irrelevant to the citizenship application. Now, obviously, if it was fraud, it would be a big deal, but it isn't. And so many people are concerned and scared because of everything they've been seeing on the news. And so the question that we're trying to answer today is, should I still apply? And whether you are a green card holder, whether you're an international student, whether you're on the H-1B visa and you're trying to file for the extension, earlier this year, we did a live show talking about how USCIS and the service centers is absolutely chaotic. And you've been seeing a lot of these, I'm sure. Random requests for evidence, a notice of intent to deny, an incorrect denial that you have to try to overturn. Why is it so messy and why is it so complicated? We did that video in the past explaining, well, it's because they're understaffed. A lot of it is new policies that's coming out. But now I can affirmatively say with the new director of USCIS, we are seeing heightened scrutiny. We've seen people applying for green cards, and with a lack of a doctor's signature, a lot of things gets bounced back. Think about that. Some people, they file for adjustment of status. If the adjustment of status is rejected, they can no longer file it again because they're out of status, right? So let's say somebody who's on a tourist visa, they file for adjustment of status. If this adjustment status gets denied and bounced back, their tourist visa is already out of status. They can no longer just file another adjustment of status. They actually have to leave the country, potentially wait outside for a year and a half, maybe 2 years or even longer before they can potentially get the visa to come back into the US. And for something as small as a missing signature from a doctor that they sent privately to the government without the client's knowledge or understanding, right? Like, I understand if the client filed the case themselves and they didn't sign, they gave the wrong check and the case gets bounced back. That's horrible, but we've seen that happen. It's the mailrooms issue. It's not USCIS policy, but now we're seeing USCIS return a lot of cases that are like this. Small mistakes, insufficient documents, denial, rejection, without even a chance for a request for evidence. Or they get called in for an interview and then an 8-page denial notice. USCIS standards have become stricter. Now I can affirmatively say that. Just a few months ago, I said that has not yet happened. USCIS, both at the service center level and at the field offices, right? These are two different agencies, or same agency, but two completely different functioning bodies. They have gotten stricter now. It is very clear that USCIS is performing a very similar role to CBP, to ICE, to the Department of State, in the consulates and embassies abroad, and applying a much stricter requirement to all the applicants. Now, what does that mean for people? What does that mean for you if you are applying for a case? Just know that it is still your right, right? If you fit the requirements, maybe they are stricter. Maybe instead of 10 documents, you should provide 15 or 20. Maybe they haven't updated their checklist online for you to see exactly what they're looking for, but you can still fundamentally qualify, right? Maybe they're stricter on your financial ability, whether or not you can survive in the country and whether or not you qualify for the public charge for them to deny you or not. So provide a little bit more documents. Instead of 3-month bank statements, provide 3 years to show a pattern, an increase in your bonuses and your HR letter recommendation saying that you're doing a great job, right? Every single different area of application, whether you're applying for a visa, a change of status, an adjustment of status, and a citizenship, there's still all these bodies of law that is still there. And officers cannot be Congress. They are not Congress. They cannot create laws out of thin air. They can adjudicate, they can stick by the guidelines of the rule, and they can potentially ask for a few more documents, but these are optional, not necessary, right? So you might get a request for evidence and you might be super scared because they want to see these 10 things and you don't have those 10 things. But guess what? Those 10 things is not part of the law. It's a nice to have, not a must have. And there's always a catch-all. You could always say, well, I don't have these things and this is why, but that doesn't mean my marriage is not real. That doesn't mean I was not here at the right time, at the right place to qualify for the 245I. That doesn't mean I cannot get a travel permit, right? What you want is not necessarily what I have, but what I have is what you don't know, so here it is. So prepare your case better. At the end of the day, USCIS officers, they have to abide by the law. And if they don't, you could definitely take them to court under the APA. And also, a lot of these officers are kind and nice and want to help. It's just that now it's a different policy, so they have to stick with a higher guideline, okay? I have lots of examples of these, which in today's success story, we're talking specifically about an L1 case that illustrates this perfectly, right? We filed the case. There was a really, really tough request for evidence directly issued by the director, not another officer beneath him. There's no other code, just director directly wrote to us. We were scared to death. We thought the case was going to be for sure denied, but we were able to overcome it. So we'll share that success story in a bit. But this news is just talking about the effect that the public media is having on the immigrant community these days. From seeing the denaturalization news, from seeing USCIS go after children. So let's talk a little bit about that, right? So very recently, we just saw USCIS post about how they think the special immigrant juveniles are criminals and fraudulent. And they specifically gave the example of many of these supposedly children are 18 to 21-year-old gang members that somehow squeeze through this loophole and is getting a green card. And therefore, they're planning on attacking the system. I'm not going to say that that does not exist, but I am going to say that is a small percentage. Reason being, 18 to 21-year-olds, you don't even qualify for a special immigrant juvenile unless you're in a few particular states. Largely in the United States, most of these cases are under 18, far under 18. They don't even speak the language, most of these kids. And they've been abandoned or abused by parents, and they are now stuck in the courts, and there's guardians involved, and there's so much harm to so many children across the United States. But just if this program is canceled, but just because maybe there were a few of these people that have gone through the system, now the director of USCIS is planning on canceling the entire CIGIS program or trying to shut it down. And in fact, what they're trying to do and have done already is cancel their work authorizations. And so a lot of these people are able to be picked up by ICE and put in detention. Kids put in detention, even though they qualify for this special immigrant juvenile, that they can get green cards through a congressional law. But it's just because USCIS is so backed up with their paperwork and their processing, so they cannot adjudicate it fast enough. The visa was used up, and so now these kids get put in detention, right? They're not illegal immigrants with criminal backgrounds. They are just in a backlog, and yet you're going to put them in detention. What image does that put on us in America? So anyways, people have been seeing these news, and fear is being felt throughout the entire community. And people with really good applications are scared of even filing for what they deserve, right? If you're a green card holder, you can get a citizenship, right? The United States have done that for decades, and you fully qualify. But now, because of a traffic ticket, you are scared to apply because of what you see on the news. I just want to, if there's anybody watching, I just want to encourage you that you just have to work a little harder at preparing a little bit better case. But anyways, that is the news that I want to share with you all. Feel free to ask any questions.
Okay, what if we are a U.S. citizen and we want to fix the paperwork for our parents?
Wonderful. So I'm assuming what you mean is your parents might be undocumented, or your parents might have something wrong in their immigrant background where they might need a waiver. So if you are a U.S. citizen, you can petition for your parents and that with the I-130, and then they can be in line in the queue to be able to get a green card. If there's some problem with their immigration background, their case will be denied, and that's when you file the waiver. Unfortunately, parents cannot prove extreme hardship on children to qualify for the waiver. Parents typically have to prove extreme hardship to the spouse of a green card holder, a U.S. citizen, or their parents. So you almost have to figure out a way to get one parent the green card or citizenship first, or get your grandparents a green card or citizenship, and then you can potentially qualify for the waiver. But look into that, right? That's a 601. But there's plenty of other situations that you might want to strategize.
Do I have to stay in the U.S. for 3 straight years before I can apply for citizenship? I have an IR1 visa.
Look into the N470, and that is something that allows you to preserve your physical presence in the United States, thus qualifying you to still apply for citizenship even though you're out of the United States. So another way to put it is, in order to apply for citizenship, you're supposed to be living in the United States for at least half the time. That's one of the requirements. Well, some people have to leave because their work sends them abroad. Some jobs qualify for this N470, and if you can apply for it, qualify for it, then even though you are not in the United States, you can still apply for citizenship. Now, obviously, if you work for the military, you don't even have to apply for N470, you just automatically qualify. But it makes sense, you're serving the country.
As a DACA recipient, should I leave the U.S. and try to have someone else petition me to be a U.S. citizen?
As a DACA recipient, should I leave the United States and have somebody else petition you? Why can't they petition you here and now? I'm assuming the question is you want to be able to get a green card. And if you're a DACA recipient and you don't have any meaningful way to get a green card here, you're thinking maybe should I leave the country? Like let's say you go to Germany or go to Canada or go wherever home country, and then an employer sponsors you and you get a visa, you come over and you adjust status and get a green card. So the answer is if that qualifies and you have all the pieces in play, you have a good employer, you have a good, somebody else who can petition you, you can qualify for the waiver, you could leave and you could come back. That's definitely a viable option.
Are you in New York?
I am in California. We're in Cerritos Artesia, next to Anaheim, right next to Disneyland.
I've been waiting for 9 years. Now my visa bulletin is current for I-130, but there's no update. F2B visa, it's been 4 months and the status hasn't moved.
If your priority date is current, that means that NVC, National Visa Center, is supposed to now contact you to let you know it's updated, and so you can go forth with the DS-260 and then the consulate. And so you're really waiting on the National Visa Center, so you can contact them so that they can contact you.
If you're a U.S. citizen, you applied for your citizen. You applied for your sister. How long does it take before you get an answer?
The first step is to file the I-130. The I-130 takes approximately 1.5 to 2 years, 2.5 years nowadays, especially if it's a sibling of a U.S. citizenship application. So it's a long time. Now, even after that's approved, before the priority becomes current, before they can even go on to apply for a green card, that could take an extremely long time. You want to check the visa bulletin, depending on where you live. If you're from India or Philippines, you might have to wait decades. Other countries, still extremely long.
Will they still deport people to Cambodia because of the war with Thailand?
I do not know. I haven't heard anything about this, especially recently. Typically, if somebody is being deported, the host country has to be able and be willing to take them back. That's part of the huge news that you're seeing, why some people are being deported to some other places or detained in certain places, because some host countries are not willing to take them back. And that's where you see all these big fights. Other reasons are maybe the host country is willing to take them back, but then the applicant, based on their due process, they're trying to fight it through immigration court, habeas corpus. Well, then obviously they're not going back. But your situation, I think you're assuming the person wants to go back, is willing to go back, but the host country is not willing to accept them, then that becomes a problem, right?
If someone got their advanced parole approved and they have DACA, is it safe to leave and then come back?
We have been advising, yes, because so far all of our clients have successfully entered back. My advice is document well your reason of how you got the advanced parole, humanitarian work or schooling, right? And then actually fulfill that promise. Really go do what you said you were going to do and then come back and then document that well. Don't just go for a day and then come back and say, hey, I'm just trying to game the system, because these officers see right through that. Additionally, also prepare your entire background, right? I mean, at least have a folder. You don't have to explain everything, but if they do ask, you have everything. How did you qualify for the DACA? Are you a good citizen in the United States? Are you working? Do you have proof of no criminal history? You don't have a crime of moral turpitude, right? So have those ready, and I would encourage you to still go, because once you come back, you obviously know, then that paves a path for green card.
What are the consequences of self-deportation without accumulating any unlawful presence in the U.S.?
If you self-deport, that is on your record, and once you have a record of you self-deporting, in the future, anytime you apply for visas, immigrant or non-immigrant, you will always have to answer yes, you have been deported, and there will be a long explanation, and sometimes you won't be able to qualify any future waivers. Now, the fact pattern that you mentioned is actually quite unique, because you're saying, can I self-deport without accumulating unlawful presence. So typically, the only situation we see that happen is if it's under 180 days. But if you're here for under 180 days, there is no even self-deporting issue unless you're a minor. So maybe let's say you came into the United States when you're 12 years old, you stay here till 18, you're not technically accruing unlawful presence, and then you self-deport before 180 days have accrued, and in that sense, you don't even have to quote unquote self-deport. You just literally leave the country, right? The United States is very okay with people just buying a ticket and leaving. So self-deport is typically applying to people who have been registered with ICE already. They already know you're here and they want to deport you. And instead of them deporting you, you self-deport. But in those situations, people have already accrued oftentimes years of unlawful presence.
I came to the US with a student visa and I applied for asylum. Should I be worried about removal?
We don't do asylum cases, but from what I have seen and heard from my colleagues, you understand that in the asylum proceedings, in the immigration court, if the judge during the immigration court proceedings decide that you don't have a bona fide case, ICE can immediately go and pick you up.
How should I write a hardship letter for my dad if he gets deported? He supports my family financially.
So this is how you want to write your letter to prove extreme hardship. The government doesn't really care about your hardship as a child. The entire focus should be on the extreme hardship that would be caused to your mother, presumably. So without your father, your mother would suffer extreme hardship, and therefore the government should forgive him his wrongs, him immigration wrongs, and grant him the green card. So your entire letter should be from your perspective, how removing your father would cause this much hardship on your mom. And maybe it's because now your mom has to take care of you as a single mother. Maybe because you have unique needs. Maybe you're disabled, maybe you are in your growth spurt, you have these conditions, and your mom and your dad are taking care of you now. But without him, it will all fall on her. And what would her life be like? How does your father help your mom? You want to be detailed, treat the officer like it's a counselor sitting right in front of you. You're preparing the story, you're writing everything out, and you're handing this letter to the officer. And you have to assume the officer is not going to read anything else but your letter. How can you convince the officer that your dad is that important to your mom, to you?
My wife was brought into the US as a baby. Is there a way to get her status without her having to leave the country?
It depends on how she was brought into the country as a baby. If she was brought in without any entry stamps, she had no passport, or she had no stamps, she didn't enter with inspection, then you might have to go through the waiver process. You petition her, you're a U.S. citizen, file for a waiver, prove that without her, your life will be miserable, she could get a green card. If she was brought in with documents, she came in as a tourist, as a baby tourist, and then she overstayed. Well, if you're a U.S. citizen or a green card holder, you petition her, you could get her a green card.
Is it safe to travel internationally as a naturalized citizen with criminal history?
If you have a drug offense, let me take a big step back, okay? When you leave the country and you come back in, as a citizen, CBP Customs, when they are looking at you, they're not looking at you for your immigration status issues because you're a citizen. They almost have no authority over citizens. However, if they're looking into their past and you are flagged by the Department of Justice, by the police force, you have a warrant against you, they are police officers as well. So they can arrest you just like any officers can. But for immigration purposes, they almost have no authority over you. If you're a green card holder, if you're a visa holder, then the customs officers have a lot of immigration authority. They can confiscate green cards, they could put you in detention, they could contact ICE. But as a US citizen, naturalized or born here, customs have to let you in unless you're involved with something that you really shouldn't have been involved with, and there's a Department of Justice, they're trying to denaturalize you, there's a warrant against you, then they can execute that. Okay, so hopefully that helps.
What's your advice on VAWA?
What's your question on VAWA? Right? We do a lot of VAWAs, but what is your question about it? President Clinton enacted it for the past 25 years. It's helped a lot of people get green cards. Yeah.
Okay, so someone accessed my USCIS account and changed the address. So how do I get that info from USCIS for court?
I honestly don't know. Yeah, I have no idea. That has never happened to us. I hope USCIS has a good tech support that can help you change your password.
I'm a green card holder. I'm barely applying for citizenship. How long will that process take?
From the moment you file, typically it takes 6 months to 9 months in non-election years. And then after the interview, if it's a clean case, they should approve it within a month. Sometimes they can approve it the same day. But citizenship cases also, some cases notoriously take years and years with background checks to the point where you have to sue the government. And so if your case is extremely complicated, be prepared that it could take 1, 2, or 3 years. And you just have to decide when is too long for you before you sue the government. They are supposed to adjudicate every naturalization application within 120 days of interview. So anything longer than that, it's your right to sue them.
Can my wife help me get my papers, so adjust status, if I have a DWI on my record?
Yeah, we've seen plenty of people with DUIs.
Is CSPA age frozen after filing, concurrent filing, I-485, and the F2A?
No. The Child Status Protection Act, the formula, the time you freeze it is not dependent on when you filed your 45 or DS-260. That is only one small conditions. Several conditions have to all be met before your age can be frozen. So when you are eligible to file is actually way more important than when you actually filed, right? So maybe you're eligible to file July 1st. Your date can be frozen at July 1st. You filed it September, a couple months later. Well, it was frozen at the time that you're eligible to file. That's a very, very important distinction. Now, there is the seek to acquire part, which is from the time you are eligible to file your case, you have within generally 1 year, generally, to actually try to do it. And if you didn't, you might have abandoned it. So you go down a rabbit hole of that issue. But when you're eligible to file, it's far more important to when your age is actually frozen.
Okay, so someone is prepping for their N400 interview, right? So they have a couple questions. They had a couple speeding tickets as a green card holder. TurboTax messed up their taxes 1 year, so minor mistake on their taxes. And then, so first of all, will that affect the N400 interview?
I would not be concerned about any of what thing you just said. It is very human to have that happen to you. The thing to be concerned about is if when somebody pulls your background, which USCIS will do right before your interview, are they going to see there's a tax lien against you? So a CPA messed up, or whoever messed up on your tax return, did you amend it, right? Or was it such a bad mess up, now IRS is going to go after you, and they put a tax lien. Then that will pop up on USCIS's side, and they'll see, oh, this person is trouble. A mistake, you didn't put a dependent here, you calculated your overtime incorrectly. Those are not what USCIS cares about. Speeding tickets, again, it is not a crime of moral turpitude. It is not a big issue.
I have a 2-year extension while USCIS processes my removal of conditions, can I travel to Canada?
How long are you traveling? When you come back, you better have a good explanation, right? So what's interesting is a few years ago when I was talking with a lot of CBP officers, a lot of them said, as long as the green card is valid, they have a reentry permit, or in your case, reentry permit. As long as those are valid, they don't question too much more. You're eligible, even if you're like a 751 applicant or you're a 526 applicant, right? You are in the middle of conditional removal. You filed the 829. Well, your documents are valid. You have a good explanation. That's fine. Nowadays, they actually do question a little bit more. If you are in a marriage-based removal condition and you went back to Canada for a weekend, that's fine. People leave all the time. But you're supposed to be married to a U.S. citizen and you are removing the condition, and yet you left for 6 months. Now they could get suspicious and they could ask more. So as long as you're able to prepare an explanation, you should still be fine, but just prepare that explanation.
I'm waiting for my F2B visa under my mom's green card. If my mom becomes a citizen, will my visa be delayed?
You can upgrade. And then it depends on which is faster. So if it's faster, then good for you. If it's slower, you can stay where you are. So it will only benefit you.
What about visa overstays or a prior green card denial? Does that affect N400 interview? Does that affect future processing?
What's the question? What a visa overstay, and then what?
A prior green card denial.
And then presumably after the green card denial, you successfully got a green card now, and then you've stayed here for 3 years or 5 years, and now you want to apply for citizenship, right? The answer is if you qualify, go for it, right? Like, so, there might be multiple denials, but
they don't have a green card now. So maybe they're applying for a green card.
Oh, then how? Okay, yeah. So apply for the green card. Once you get the green card, then wait the 5 years, for the time that you qualify for citizenship, and then apply for citizenship, right?
But does the visa overstay or the green card denial reapplying for the green card?
It does not automatically deny you.
But is it like an obstacle to overcome?
Sure. I mean, it depends on it depends on why the case was denied, right? It depends. The overstay, was there a waiver? Did you overcome it? Yeah.
Does TSA and USCIS coordinate? Can they see?
I don't know the information, so I cannot say for sure.
CBP and USCIS do coordinate. Is that correct?
CBP is the customs officer, right? TSA are the people, right, checking people in, but customs officer are the ones who are taking your passport, taking your green card, interviewing you. CBP's system is linked with USCIS system, so they could see each other's stuff, but not fully. For example, a CBP officer could see, oh, you've applied for a reentry permit, or you applied for advanced parole, but they don't see the contents of it, right? So you might have applied for advanced parole, emergency advanced parole, because your mother was ill and you need to leave, and there's just humanitarian cause, and you're on DACA. They don't see any of that. They just see it was approved. On what date? So they see each other's systems, but how much, it depends.
Okay. Is it safe to do an advanced parole if I had a DUI case that was dropped to reckless driving, and they had a DACA motion terminated with the police department?
Ultimately, it depends on if there was a conviction. So docket dropped, case dismissed, not dismissed in prejudice, not expungement. I'm talking about like there just was no final action. They withdrew the case. That will be in your favor. Even if there was a conviction, if it was a one-time thing, and the criminal conviction and the fines and the jail time does not exceed 1 year, you might still be able to qualify under the petty theft exception. So your green card is still intact. Hopefully that helps.
I am 28. I've been here since I was 5 with a green card. I have CWOF, and I'm waiting for renewal.
You're waiting for renewal for a green card, and presumably you're asking, should you apply for citizenship? No? Okay, well, you should apply for citizenship, because green card rights are being stripped away at a pretty fast pace.
Does applying for advanced parole trigger a decision on a pending adjustment of status? It's been 4 months since the interview, but no decision.
completely separate. I could say a few years ago, USCIS made a blanket-wide policy because they were so short-staffed. They moved a ton of officers that were adjudicating work permits to the green card unit. So they were just approving green cards faster than work permits, right? Because why approve the work permit and then approve a green card? That's like a two-step process. Why not just directly do the green card? That policy, I think, has largely been changed. So now they're going back to normal processing. So I don't think applying for a work permit would speed up your green card.
I've been a resident here for 28 years, 30 years. I've had 2 DUIs 20 years ago that were resolved. Now, will those DUIs cause problems for the citizenship now?
Problem in the sense of you would need to disclose, and you would need to explain, and you would need to prove good moral character, especially in the last 5 years. So somebody who didn't have it might not be questioned as much. You might suffer 10 minutes of additional questioning about these issues. But if you're asking, will it fundamentally deny your citizenship? The answer is no. We've seen plenty of people with that and still gotten their citizenship. Again, you are talking to an individual, to a person. They have their requirements under the law, good moral character. It is fuzzy. There's a lot of things that they can adjudicate and think through. And so how do you persuade them? So what is your job? What recommendation letters do you have? And what's everything that's going on in your life? If you're able to kind of convince and explain that to them, they can still approve your case.
Okay, I'm married to a U.S. citizen. I have a green card for 2 years and 9 months this December. Can I file for citizenship?
So if you're still married to a U.S. citizen, all you have
They
to do
are.
is be married to a U.S. citizen for 3 years before you can apply.
Okay. I came through the border, probably unlawfully, and I'm married to a U.S. citizen. Can I still apply for a green card?
Yes, but you have that additional 601A, presumably. You have no other issues. So you can file the I-130, you can go through the NVC process, the case will be denied, you file for the waiver, it will get hopefully it will get approved. You have a good case, argue it. Once it gets approved, then you go back to the consulate, you get the visa, you come back in, and voila, you got your green card. So that's the entire process.
I have a green card, but I did have a DWI case back in 2013 before I applied for the U visa. Can I travel now? What's the risk?
When you travel into the United States with a green card, the CBP officer will be able to see also everything else that's happening. Right now, they are under a heightened scrutiny, a zero tolerance. They're mainly going after people with drug offenses. If it's something that happened before you got the green card, if it's something that's not a drug offense, if it's not a felony, generally, they might give you a few questions. If you can prove you're a good person, they still let you in. You're not detained by ICE. That's from everything that we've seen. But if you have the drug offense, if you have multiple crime of moral turpitudes, especially within the past 5 years, those are the people who are high risk.
Is it safe right now for undocumented immigrants to fly domestically?
Technically, there's no CBP officers in domestic airports, just like the past. But we have heard that there are CBP officers walking around, but there's no obligation to present anything to CBP officers at the airports. So up till now, we haven't heard of any terrible situations. So take that with a grain of salt. Obviously, still wouldn't recommend traveling too much. Yeah.
My STEM, okay, we're going to answer 2 more questions. My STEM OPT is ending soon. I don't have EAD, C9. Can I still continue to work with my pending AOS, APPL?
If you have an adjustment of status, you should have applied for a 765 work permit based on your adjustment of status. You might not have done so because you already have an OPT work permit. If you are concerned that it's going to run out of time, you should apply for a new 765. If you don't, and your OPT work permit runs out, then you cannot work any longer. You can stay in the country, you just cannot work.
Can you use your I-485 to get a driver's license?
Depends on what state you're in. In California, you don't even have a 45 and you can still get your license.
Okay, last question. Does motion to reopen automatically stop the deportation?
No.
Oh,
Unfortunately.
okay, and this is a very surprising question. I crossed the border with 2 kilograms of cocaine. Can I get a green card?
I highly doubt it, especially if you got caught, because drug offenses is a deportable, inadmissible offense that they are super strict on. Even people who gotten green cards 20 years ago on a conviction like that have been expunged, dismissed, sealed. I have seen, it's one of our own clients, still got picked up and is still in detention 6 months now. Terrible, terrible situation. It's a very senior, elderly man with a great family, but his mistake in his younger years is coming back to haunt him.
I want to adjust status, but I was detained for a misdemeanor, Class C misdemeanor. I was sent to ICE, no record found, not processed. I was returned. I did a FOIA background check, and nothing was found. Can I do AOS?
Go for it, right? Because if nothing is in the system, then there's nothing that the government can use to deny you. Because if they deny you, they have to find you inadmissible, they have to find you deportable, and it's their burden of proof. If it doesn't exist, if there's no documents, then they have nothing to go by. Now, just so you know, which I've had this unfortunate experience of, I went with a client to citizenship. They were about to get their citizenship. They had everything approved. Green card had it for years. Nothing against them, but the client voluntarily, out of nowhere, wasn't even asked this, voluntarily divulged that there was something wrong with the application and admitted to something. And the officer said, okay, well, based on that testimony that you just heard, denied the green card and had to deport the client. USCIS officers have the authority to make determinations and conclusions with severe adverse consequence based on hearsay evidence that are voluntarily provided. Doesn't have to be notarized, doesn't have to be sworn, just based on hearsay evidence. So, if you don't admit it, there's no records on it, USCIS does not have any documents, then they cannot appropriately determine that you are inadmissible and deportable.
I'm a green card holder. I accidentally registered to vote, which is saying you're a U.S. citizen by mistake. I then canceled it, but what's the next step?
Write out an addendum very clearly, show what you did, show the mistake, and when you apply for citizenship, if they ask, be able to explain that. Definitely do mark it on your naturalization form, because if you don't and they see it, that is misrepresentation. And explain yourself. We have successfully helped plenty of clients overcome this mistake. Again, USCIS, they understand mistakes happen. It's human to err. What they're trying to do is trying to bar people who claim they're citizens illegally voted, right? If you didn't vote, it was a mistake, it was on a DMV form, it was a school assignment, it's excusable.
Would you recommend CBP entrance or SB1 visa for a minor who's been out of the U.S. for 3 years?
Over 1 year, SB1 is almost impossible. So CBP entry is much more likely to succeed.
But you can apply for both, right?
You could apply for both, and if SB1 is denied, the CBP will see it, and it makes CBP entry just that much harder. So since the success rate is already so small, might as well don't make it any harder for yourself.
Would you recommend applying for advanced parole? I was about to, but I stopped due to new regulations.
Apply for it, because if it's denied, it doesn't harm you. If it's approved, you can still make a determination not to actualize it, not to use it, not to go, if you are just in fear of your life. But what if you finally have the courage and you got it and you go, and now you're able to get a green card, right?
My motion to terminate is pending. What's the next move?
We don't do a lot of these motion to terminate cases or motion to vacate cases, so I can't really advise on that. But you're really waiting for the judge's response, right? If you filed the motion.
I am renewing my green card. I had a DUI before I got the initial green card. I have biometrics coming up.
No problem. Go to it with a big smile. There's not going to affect you. Biometric centers are not even stationed with USCIS officers. They're contractors. They're there just to take your fingerprints. They're no different than TSA agents or anything like that. So don't worry about it. It's just a process. And then most likely your I-90 process, and then you'll get a new green card.
What's the worst that can happen if the minor does choose to do the CBP entrance?
What's the worst that can happen? The worst that can happen is the officer says, I think you've abandoned your green card or your family has abandoned your green card, so I'm going to confiscate this green card and you have to appear before immigration court.
I'm a DACA recipient. I'm married to a U.S. citizen with no legal entry, is what they said.
Okay.
Should I do advance parole?
Yeah, because that will change everything for you. If you file your advance parole and you go and you successfully re-enter, then there's a decision between getting a green card or not getting a green card.
Okay, what about having my husband petition me versus doing advance parole?
Either way, your husband has to petition you. Advance parole allows you to get the green card much faster and much easier.
Okay, last question. If you became a U.S. citizen, naturalized U.S. citizen, and then you moved to another country, am I safe?
The individual is asking, they became a citizen, and can they leave the country?
Yeah, move to another country.
So you're an expat, and then you want to come back years and years later. Yeah, lots of people do that. The United States encourages it, loves it, because once you're overseas, they don't have to give you a lot of benefits. You're not taking up road space. Yeah, they love it. Today's success story is about an executive manager coming to the United States, opening up a brand new office and employing people and wanting to start their life in the United States. It was a very difficult case because they originally wanted to apply for an E2 in a treaty trader, but we analyzed everything and they don't qualify for it. So then they now had to do the L1. But the funds were very limited. They invested just shy of $100,000 to start up this company in California specifically. And in the bank account, there was only $12,000 left. It was not a very sizable operation. They have a warehouse. They have no employees. They have a business plan. They have dreams. And so we filed the case. And the person that wrote back to us and issued the request for evidence was the director himself. Normally, when you get a request for evidence, there's a number on the bottom that says which officer issued this request for evidence. When it doesn't have that number, it is basically the director themselves. So, and many times, if it is somebody else, an associate, somebody who just joined in, it will be from the senior director and then it will be an officer's name. In this case, it was just directly the deputy associate director of adjudications who wrote back with their name, signed, challenging the case. It was a brutal request for evidence. Our team worked really hard with the client and actually responded in a very short manner. And the case got approved. There was so much to learn from this case that I want to walk you through everything. So hopefully you can see exactly what's going on because it is just so helpful having side-by-side comparison. Okay, let's get to it. Hi everyone, my name is Joseph and I'm the managing partner here at Tsang and Associates where we solve legal problems with creative solutions. And the legal problem today is that there is this teeny tiny company that is creating, fabric, clothing in the United States, and they are trying to apply for the L1 executive visa. this visa allows executives from overseas to come to the United States to start their company, employ U.S. workers, and then be able to potentially apply for a green card should they want to. But that's a different standard of proof. It's much more difficult, but at least give them the opportunity. This is the L1 startup visa. It is only for 1 year, and they have to prove themselves, extend it for 2 years. And then if the company is big enough, they can apply for EB1C to get a green card. So here's a timeline. They contacted us in January. They officially retained us in February. We filed everything in mid-April. No, mid-May. We collected all the documents by April. We filed it by May. We got the request for evidence in the middle of June because we did premium processing. We always do premium processing for almost all of our cases. Middle of June, got the request for evidence, and end of June, we filed the response, and just last week, the case was approved. So after they received our packet, they reviewed it for 2 weeks, and the case was approved. This was a very challenging request for evidence. Let me kind of show you why. They did not approve the 1-year employment abroad. They said the evidence of your organization submitted was insufficient because just having a letter from the HR was not enough. Please submit payrolls, personnel records, training records, and demonstrating a full year of employment activity and evidence. That's the first thing. We had to prove our client was employed abroad for 1 year, and it needs to be at an executive managerial level. The next thing is that the U.S. company has to prove that within 1 year, they will be able to fulfill and support an executive and managerial. So it's not good enough just to prove that in 1 year you will survive. It's not good enough just to prove that 1 year you will employ a few people and you will have some activities. You need to prove that within 1 year, the organization is big enough that it justifies an executive. That's an extremely hard part. And it goes down, please provide all of these things. You can still submit letters from the foreign company, copy of feasible study, copy of business plan, minutes of the foreign company illustrating the discussions on how to improve the U.S. entity, proposed organizational chart, so on and so forth. They also want to talk about the size of the investment into the United States and the financial ability of the foreign entity to support the client and the business in the U.S. And then went through another 10, 20 bullet points of talking about what they wanted. Then they challenged whether or not the business is sufficient in size and scope. Show me the lease agreement. Well, we provided it, but here's all the reasons why it was not good enough. But you can still submit other things, other U.S. leases, statements from the worksite, Salesforce, letters from the owners of the property management company, the deeds of the property owner, copy of the contract between the owner and the leasee, color photos of the U.S. entity's premises, copies of escrow documents, copies of the entity's floor plans and interior design, including the office. Then they challenge whether the beneficiary is the owner and the major stockholder of the company, and please provide contracts, assignments, shares, statements from the foreign entity. And it goes on for a total of 8 pages. In response to this request for evidence, we only had 20 documents. That was all the clients could provide. 20 documents, we wrote 5 pages, and we submitted it. It was a very difficult decision on how to craft this response. Because initially, in the first application, when we first submitted it, it was over 40 documents. It was over 12 pages of attorney brief explaining everything. And now we get a request for evidence challenging everything. One way to go about it is, okay, you give us 10 pages of request for evidence, we'll give you 40-page response. We initially submitted 30 documents, now we're gonna triple it and give you 90-page or 90 documents to prove without a shadow of a doubt that the case was approvable. From our reading of the request for evidence, from our reading of this director directly challenging everything. And because the clients just didn't have that much to provide, our strategy was to quote the law back to the officer to show them what is necessary and what is a nice to have. You can request all these things, but the client doesn't have it, nor do they want to, nor is it necessary. And so in the response, which is just 5 pages, we reiterated what we previously submitted, and we provided a few additional ones in each of the category. And we quoted the policy manual, we quoted case law, we talked about exactly what's necessary. We talk about, literally every single section for every single criteria. We quoted the law back to them and the policy manual saying, this is what the officer is supposed to be looking at, what they're supposed to be adjudicating, this is what's provided. By the very nature of a new office, the officer, they don't have it, but the regulation does not require it. That was the best that we could do. When the clients are able to provide a lot, we can use a lot and make an argument. But in this case, the client couldn't. There was only $12,000 in the bank account. How do you come up with a feasibility market study to talk about how grand the U.S. marketplace is and how much, clothing they could sell, right? That's just not the scope of this particular company. And maybe USCIS is just saying, well, we don't want small companies anymore. Every company we want needs to have this big market study, needs to be this well-funded international enterprise. That's fair. We respect that. If that's the case, make that part of the law. But it isn't. It hasn't been. USCIS has the authority to request these, and that's fair. That's what the officers wants. But we don't have to provide everything. So we explained why we didn't have certain things. We explained what we did have, and we furnished additional ones. We quoted the law back, and we crossed our fingers because you never know what the administration is going to do. And we were very pleased to announce today that, again, this case was just approved, right? We have a feeling that that was a brand new template that USCIS is using to challenge all L1 cases. And now we have a template on how to respond to all L1 denials or all L1 requests for evidence. So it is very important to know the law, to know the boundaries, and therefore then you don't have to stress as much, right? Because again, we are all playing in the same playing field. USCIS is not supposed to just make up random new rules. Different administration changes, they're supposed to be more strict. That's fair. Catch fraud. But this client is not fraudulent. They're just small. They're not fraudulent. Okay? So, with that being said, if you guys have any questions about L1, about EB1C, feel free to reach out. Thank you. Take care. Oh yeah, by the way, this case done by Andy's team, so proud of him. Take care. Bye-bye. All right, so that was the L1 success story. See you guys next week, Thursday, between 12 to 1.
Thank you, everyone. Sorry we couldn't answer everyone's questions. We will be here next week.
Yeah, take care.
Thank you
Bye-bye.
all.